Following up on my previous video, today I'm going to talk a little bit more about how minor children can be affected if their parents die without a will. If you are a parent of minor children, the most pressing issue surrounding the drafting of your will is probably guardianship. Parents are generally more concerned about who will take care of their children than who will get their stuff. If your children's other parent is still living and is a fit parent, this may not seem like a big concern. In almost all circumstances, a surviving parent will take custody of the children. The unpredictability of life, however, makes it important for you to still name a guardian in your will. At the death of a child's guardians, a court will name a new guardian. If you name a guardian in your will, the court will almost always award guardianship to the person you name. If you do not have a will, however, the court will determine an appropriate guardian on your behalf. While the judge will try to make a decision that is in the best interest of your children, the judge will not have your knowledge or personal experience with any of the potential guardians. Consequently, his or her assessment will be limited to information that can be presented relatively quickly before a court. This can have some unfortunate consequences. First, the judge's limited perspective may result in the court's awarding guardianship to someone you would consider to be an undesirable guardian. Without your making your desires known through a will, an individual you would never have wanted to raise your children may suddenly become your children's legal guardian. Another unfortunate result, however, could occur where there are multiple desirable guardians. While this might not seem like a bad thing, if there are multiple family members, such as both sets of grandparents, that desperately want guardianship of your children, conflict could ensue. This conflict could result in lengthy and traumatic court custody battles with your children caught in the middle. A simple will in which you express your wishes, however, can help avoid all of this. For this reason, every parent with minor children should have a will, even if they do not have much property. While perhaps not as emotionally noteworthy as the issue of guardianship, it is also important to consider the effect dying without an estate plan could have on your minor children's inheritance. Your children's inheritance may be significantly more than you first realize, particularly if you have a life insurance policy. Without proper planning, your minor children could gain unfettered access to their inheritance when they are as young as 18 years old. There are two types of property to consider in this regard. The first is probate property. Probate property is property that is distributed according to the instructions found in your will. The second type of property to consider is non-probate property, which is property that is not disposed of through the instructions of your will. The most notable non-probate property in this regard is life insurance proceeds. While the recipient of your life insurance proceeds will be determined by your policy and not your will, through your will you can create a trust for the benefit of your children or anyone else, and then name that trust the beneficiary of your life insurance policy. So, say for example, that you pass away and are survived by a 17-year-old child but no spouse. You do not have very much property, but you do have a $250,000 life insurance policy. Without a trust, your child could receive uninhibited access to these funds within a year of your death. If you do not think your child would be ready to manage such a large sum responsibly while still in high school, a trust may offer a good solution. Through a trust, you can appoint a trustee to distribute funds to your child according to your instructions until he or she reaches an age you deem appropriate to inherit the full amount. A trust created through your will, otherwise known as a testamentary trust, can provide a good solution to a variety of needs. They allow you to set predetermined goals, providing instructions for the use of your property and money, including life insurance proceeds as just discussed. The trustee can distribute funds for college, living expenses, and anything else in accordance with your instructions. A trust will, however, prevent your child from going out and blowing the money on a Maserati. A trust also allows you to name someone you trust as the trustee. The trustee is the person who will manage the property to ensure that it is used for the purposes you specify. This is a better solution than leaving property or life insurance proceeds to someone with the expectation that they will take care of your children, for example, because doing so allows them to take your property under no obligation to actually use it for the benefit of your children or according to your instructions. I hope that this has been helpful. I have included my firm's information here. So if you have any questions, please feel free to call or email me.